Pronounce it correctly.
Good morning, Your Honors. James McCray from Greater Boston Legal Services for Doris Garcia. General Law, Chapter 121B, Section 32, establishes some unique eviction protections for public housing tenants. One of them has to do with grievance rights that exist, and the grievance rights that we have under state law differ somewhat from those under federal law and may provide grievance rights that don't exist under federal law. And this Court has previously declared in Spence v. Reeder that the fact that those state protections exist is not preempted by federal law. In Spence v. Gormley, the Court had to deal with a separate provision of 121B, Section 32, the cause requirement for eviction. And the Court determined that while that cause requirement generally means that the head of household is responsible for the conduct of other household members, that the head of household could come forward with evidence of special circumstances showing that they could not foresee that the household members were going to engage in wrongdoing and therefore should not be evicted.
But what was the lease in Spence versus Gormley was quite different on this point, right? The lease language?
That's correct, Your Honor. The lease in Spence versus Gormley was actually fairly general.
Right.
And so the Court there found that the lease by itself certainly provided the housing authority with the ability to evict for any kind of conduct. Actually, here, Your Honor, the lease provision is somewhat different than what the federal law currently requires. The lease provision here says refrain or cause to refrain from engaging in wrongful activity by household members.
So isn't that so if one fails to cause to refrain a household member from committing one of these acts, that's the basis for eviction?
That would be the basis for eviction under this particular lease, Your Honor. The federal law actually has the phrase assure that household members will not engage in wrongful activity. For some reason or other, the housing authority here is using a different lease than what federal law requires. Arguably, that may mean that this Court does not need to reach the federal law issue. Nonetheless, it is an important issue that day to day is coming up throughout the Commonwealth.
So your position is state law trumps federal law, basically?
My position, Your Honor, is that federal law authorizes but does not require eviction.
And we have an innocent tenant rule.
And you have a special circumstances defense. And basically where the housing authority has a range of discretion as to whether or not to proceed with eviction, federal law certainly gives housing authorities the tools and the authorization that where there's been a lease breach, where a household member is engaged in wrongful criminal activity, they can bring a case to court. But then the question is what happens in court? And our position is when it comes to court, the court can decide that it is not an appropriate remedy for the eviction case where the tenant comes forward and provides evidence that they could not foresee the wrongdoing. In this particular case, the trial court cut off that discussion. The tenant started to present that, had raised an answer that raised that, and the trial court said,
I'm precluded by Rutter from doing that, correct?
correct. He said, therefore, I'm only going to look at the question about whether or not these were actually household members at the time or whether or not they engaged in the wrongful activity. Otherwise, Rucker precludes this.
Should we be looking at this? Should we be looking at this administrative decision to evict? Judicial review of that, should we be looking at that through the lens of abuse of discretion? You say that the administrator under federal law can evict but need not. There's discretion that the administrator can exercise in determining whether or not to evict. So shouldn't we be looking at that through the abuse of discretion standard, and perhaps your argument about absolutely no fault, no knowledge, no ability to control would play into that analysis?
Your Honor, I certainly have, under a fallback argument that we've raised, said that if there is some displacement effect by federal law on state law, such that right now the Spence versus Gormley defense is an absolute defense. If the tenant comes forward and provides that evidence, that's basically the end of the case unless the housing authority rebuts the evidence that the tenant brings forward.
And there can't be a lease. There can't be a lease, even with federal housing, that goes beyond what the special circumstances defense provided in Section 32.
I'm sorry, Your Honor.
Can a housing authority with a federal housing project write a lease that requires the eviction of a tenant whose family member commits one of these acts?
No, Your Honor.
So Section 32 trumps, Section 32 controls.
Section 32 would certainly control over the lease absent federal preemption, Your Honor.
And there is no federal preemption, you're saying?
Well, our position is that there is no federal preemption. It's certainly the Housing Authority's position that there is federal preemption, and it's also HUD's position, and it's amicus that there's federal preemption, although HUD has issued no regulation preempting
Can I
these state
ask
law
you about
requirements.
that? You drew to our attention a decision from Ohio,
Correct.
which I went to look at, and there I find from HUD, it doesn't have a regulation, but letters from HUD in the wake of the Rucker decision that essentially say no preemption. It's, in essence, it's, and I'm quoting from HUD, interpreting Rucker, urges public housing administrators to be guided by compassion and common sense and to consider the seriousness of the offense and how it might impact other family members. And then there's a June 2002. I don't know whether I can take judicial notice of those. They are apparently not in evidence here, correct?
I believe they are in evidence. I believe they're part of the record. They weren't a part of the record before the trial court. I will acknowledge that.
You have submitted them here, the
I-
HUD, the HUD letters?
The HUD letters, I believe, Your Honor, are included in either the appellant's brief or the appellee's brief.
Okay. Well, if they, I'll find them if they're there.
Your Honor, the other thing that Ohio case does reference is the fact that when HUD adopted these regulations in 1991 and again in 2001, there were explicit statements that there was no intent for federal preemption of state law under an executive order having to do with federalism. Had HUD intended to preempt, it would have said otherwise, and we've included some other examples where HUD has been very explicit about doing preemption. For example, there was a case in Washington State where there was a medical marijuana law, and there HUD clearly came out and said the fact that you may have a state medical marijuana law does not mean that it's legal to use marijuana in federal public housing.
I have found the letters. They're pages 77 and 78 of your...
Would you agree that the innocent tenant defense conflicts with the goals and objectives of HUD?
I would not, Your Honor. I think that what Spence versus Gormley has established and what HUD has as a general framework mesh. That is, the notion is that tenants are responsible for the conduct of household members, and if household members engage in wrongful activity, eviction can occur. That is a lease breach. That's the same under both state and federal law. The question...
Like a zero-tolerance approach, though, isn't it?
It is saying that it is a basis to proceed to court, that we don't give you a second chance. It is a basis to proceed to court. On the other hand...
And you will be evicted.
And you will be
Or would you say you will be subject to consideration for eviction?
You will be subject to an eviction proceeding being brought against you. You will be subject to having your tenancy terminated and being in court. And our position then is once you're in court, the federal scheme provides that if there are available state law defenses to you, you can raise those available state law defenses. That is part of the federal scheme. And the Spence versus Gormley defense is a state law defense that's available. In Rucker, the Supreme Court only had to deal with the question about whether or not federal law created an innocent tenant defense, and the Supreme Court said absolutely not. There's nothing in here either implicitly or explicitly that would provide an innocent tenant defense. When Congress has wanted to create a federal innocent tenant defense, it has done so explicitly. But the court did not touch on any issues about whether or not state law might establish other defenses to eviction or whether or not there may be other considerations a court might have in deciding that the eviction remedy was too harsh or too severe. And that was one of the considerations that this court had in Spence versus Gormley, was that applying an across-the-board rule that would say in all circumstances where there was wrongdoing by some household member, everybody's out, would be too harsh a consequence. And that's why the court said the tenant can come forward, bring in that evidence. Now, it may be, again, back to the displacement issue and the question that Justice Cordy raised, that there may be circumstances in which a housing authority might have a very strong case in which they would say, well, this particular tenant would not agree to remove their adult son. And their adult son is a problem and is going to continue to be a problem. And that's why, Your Honor, we need to have the whole family out. And I believe that that does raise a tension issue around the absoluteness of the Spence versus Gormley defense versus the range of discretion that's provided under federal law. And there I would submit that it may be that there is some backup that needs to be done where the court would say, well, let's hear what the tenant has to say about those circumstances. Let's hear from the housing authority about why that particular remedy won't work. And it may be that the box to fit it better into is an anti-equitable forfeiture box where the court can then craft those remedies. We now have some statutes that weren't available at the time that Spence versus Gormley came down.
Could you, I interrupt you just a minute, please. Could you address the argument by the housing authority that your client waived the special circumstances defense in a trial? She only presented evidence that her sons were not members of her household, and the judge didn't believe that.
Your Honor, there are 2 points there. One is the housing authority certainly recognized that there was a Spence versus Gormley defense raised in the tenant's answer. In the very first page of the trial transcript, there's reference there to this defense that the tenant intends to raise is foreclosed by Rucker. Now, that wouldn't have been the Bruno defense. That the BHA versus Bruno defense is not covered at all by the Rucker situation. It could only have been the Spence versus Gormley defense that they were referring to. And later on in the transcript, when the tenant is beginning to testify and the court then interrupts her at some point and then starts to talk with her about the Rucker case and says, basically, I believe what you're saying, but even if I believed what you were saying, it wouldn't make a difference. So why don't we proceed on to you submitting evidence?
Well, what about her answer? What about her answer? Her answer said she wasn't responsible because her sons didn't live with her at the time of their arrest and were not household members.
There are actually 2 parts of the answer, Your Honor. There's a separate part, a box where she checked where she was saying, I did not know or have reason to know of the conduct of household members. So you are correct, Your Honor, that there's a more explicit statement that she said in which they were no longer living with her, but there is also in the general answer a Spence versus Gormley style defense raised. Back to the question about equitable anti-forfeiture remedies, it would be appropriate for the court then to consider whether or not the meshing between what the tenant said and what the housing authority said in a particular set of factors might mean that there would have to be displacement. But what I believe the housing authority's position is basically the tenant, basically the exercise of discretion is solely up to the housing authority. That once there's a lease breach, it gets to court, and the court's role is simply to determine whether or not there's been a lease breach. And that is what we submit would be improper, that we think that the court has a role under Spence versus Gormley to determine whether or not there has been a breach of the lease, but also whether or not the eviction remedy, the ultimate eviction remedy, is appropriate and if there are some other remedies. 121B Section 32B, for example, allows housing authorities to get injunctions against non-household members. Certainly as part of an equitable anti-forfeiture order, a court could order that the tenant's ability to remain in the premises would be conditioned upon the exclusion of household members who were engaged in wrongful activity, or could set other terms. All the time there are agreements done in the housing courts and in the superior courts and district courts across the Commonwealth in which housing authorities allow household members to remain, but with excluding household members and having enforceable terms. We are not asking for any change in that regimen, and we are not asking for any change in the legal framework that's existed in the Commonwealth since 1982. We believe it's worked well, as the trial court has indicated. Thank you.
Thank you, Mr. McClate. Ms. Marshall, do I have that correct?
Actually,
It's Michael.
Chief Justice Marshall, it's Michael.
Michael.
But thank you for trying. I appreciate that. Good morning, Chief Justice Marshall and your honors. May it please the court. My name is Helene Michael, and I represent the Boston Housing Authority, the landlord in this matter. It is significant that the United States of America, through the Department of Justice and on behalf of HUD, has weighed in on this issue in favor of the BHA's position. HUD and BHA and the Cambridge Housing Authority are urging you to take another look at the special circumstances defense that is offered on 21B Section 32 solely through this court's interpretation of that law in the Spence v. Gormley case, and examine it within the context of its direct conflict with federal law and how in...
May I ask you a question just on that, and just, I don't want to get off on the wrong
Yes, Your Honor.
path. If a state statute had the gloss on it that this court put onto the statute, would that make a difference?
Your Honor, no, because I believe that the interpretation of the court stands as the law in this
Okay.
Commonwealth. And
So-
if it was codified, then that would still trigger a preemption analysis under
Okay.
the implied preemption analysis, where there is a direct conflict with federal law and how it frustrates the goals and objectives of Congress.
If that is the case, it will be most helpful to me if you could address the two HUD letters. I know they talk in terms of the authority given to the housing, but essentially saying, and I'm now going to repeat back essentially what Mr. McClate said, that federal law authorizes but doesn't require. In other words, there can be special circumstances, and a housing authority could comply with a local law or decide for itself that it's going to permit special circumstances.
Well, Your Honor, yes, the Rucker Court...
And if
yes.
federal law preempts, it can't do that, correct?
That's correct, if there's a direct conflict, Your Honor. But what does come into play is the discretion of the housing authority in reviewing all the circumstances before making that decision to terminate. However, HUD has said in the Michael Liu letter, he was the Assistant Secretary of HUD, in the letter that Mr. McCright, my brother counsel, is citing, giving some direction to the housing authority of things to look at, that it does not have to evict in every case. However, Your Honors, I would call your attention to the Scarborough case from the District of Columbia Court of Appeals, in which the court said, but nothing in the regulation requires the landlord to consider any particular factors before instituting...
It doesn't require it.
That's correct, Your Honor. However, it does specify what the court's function is, which Brother Counsel and Your Honors have raised. A court's function under HUD's regulations is to determine whether an eviction meets the requirements of the lease and the applicable criminal activity prohibition, and not whether a housing provider has considered additional social and situational factors that HUD's regulations authorize but do not require.
So you're saying that those two letters essentially address the discretion of the public housing authority,
Yes.
and not the existence of the federal. That does not conflict with the Rucker decision, to the extent that you're saying Rucker says federal law does not recognize any innocent tenant defense.
Well, it does state that, but there is that ability on the part of the housing authority to examine the situation and exercise its discretion. HUD has also instructed counsel that...
Can I just ask
Yes.
you that, though? And here's preemption is preemption. It's a very powerful doctrine.
It is.
And as I read it, what HUD said specifically, because it sent the letter out to everybody, you have discretion, and presumably, if you exercise the discretion, it doesn't run into any preemption problems because federal law doesn't require it. A state, it would seem to me, can then say, in this state, running the public housing programs that we run, we are going to say, this is the way you're going to evict tenants in these circumstances. Now, that the lease
distinct-
might be a little different, but
Yes.
I want to get to preemption. And it seems to me, if the housing authority has authority, the lease has authority, the statute has authority, the court has authority, you're not running into a straight preemption problem.
Well, Your Honor, I think the United States Supreme Court addressed that issue, that the discretion rests with the housing authority, not the state, to decide whether that is something that they want to have, Your Honor. They're looking at the housing authority's discretion to determine this issue.
That's how HUD interpreted it. What the court said is federal law doesn't provide for this defense. What the court didn't say, it seems to me, at least an argument, is housing authorities can provide for this defense, leases can provide for this defense, statutes can provide for this defense. Otherwise, you don't have preemption.
Well, Your Honor, I don't see where the United States Supreme Court has said that the states can control that. It said that the public housing authorities are in the best position to determine what their community needs, whether an eviction is proper, not whether the state should offer that ability.
It wasn't before the court. It simply wasn't before the court. The court
Well, Your
didn't
Honor, then I
address
would
the issue.
present to Your Honors that if that was permitted, if state law was now codified to include an innocent tenant defense, which under Gormley includes being able to not foresee or control the household member's conduct, but also in cases where the tenant could control the conduct but did everything that he or she could have done and it still occurred. Those are the two scenarios under Gormley. In those cases, if that tenant was permitted to keep her or his federally subsidized public housing apartment, that would be in direct conflict with what Congress intended, which is to take the subsidy away when there has been such a lease breach.
But why is that the result? If the legislature really creates, if the housing authority is a creature of the legislature, the legislature can exercise the discretion of the housing authority. And here the legislature has exercised the discretion of the housing authority in Section 32 by saying there is an innocent tenant defense.
Well, actually, with all due respect, Your Honor, it was this court that
You've
interpreted
just told me
that.
that it's the same thing. That's
Yes.
why I asked you that specific question, and you said it's the same thing.
Yes. Well, in any event, the statute has not been so codified at this point. So this court can re-examine its interpretation of Spencer v.
I don't want to
Gormley.
ask the question a third way, but I just want to see if maybe federal law either requires or doesn't require. And if it seemed to me that what the court was saying, and is consistent with the two extremely nuanced letters from HUD, was you can do it. So if, for example, Boston Housing Authority decided to have this in its lease, in other words, a special circumstances defense, that would be contrary to Congress's carefully articulated policy, which you just explained to me, as much as if a state statute did it.
Your Honor, that's true, but we're talking about federal dollars for a public subsidized apartment versus state dollars.
But the housing authorities, in this case, it's Boston Housing Authority that receives federal funds, and the federal government knew that, and the Supreme Court knew that. It seems to me the Supreme Court simply hasn't addressed the issue in the Rucker case. Well,
Your Honor, I would, with all due respect, I would say it has. It is said that the housing authority is in the best position to make that determination. It has made the stricter lease, and I would counter Brother Counsel's argument that the lease does reflect what the federal regulation requires, and this is all because of the 1988 Anti-Drug Abuse Act. The effect nationwide on public housing, with in terms of drugs and violence, has required these very strict lease terms. The court in New York has looked at it purely in a contract context and not on the preemption issue.
That I can understand. That I can understand. That seems to me to be a separate issue.
But to permit someone who has, in fact, allowed a household member to engage in this conduct or has not been able to control them, it completely conflicts with what Congress is seeking. Now, counsel is seeking an alternative here under forfeiture, under the equitable principle, and I would argue that the Cleveland case, as opposed to not being a persuasive authority at best, would require the housing authority and all housing authorities to go to the federal court to seek relief if it found that, in fact, state courts were going to follow the innocent tenant doctrine. The court in the case of Boston Housing Authority versus Maria Allegria, a lower court decision, however, in that case, the housing court found that the legislature, in adopting 13919, Chapter 13919, was looking at the community good, was looking at how this will affect the people in the community, and deferred to that and did not find equitable forfeiture in that case, although it was specifically requested. Your Honors, it has been 25 years since this court interpreted 121B, Section 32, and it is time to re-examine that interpretation and find that it really doesn't matter what the tenant knew or should have known, but that the misconduct occurred. There should be no...
I take it that both you and HUD are inviting us to do this regardless of what we conclude on the preemption question.
Your Honor, I think you can, this court can still do that, can examine this, yes.
Okay.
And that is why HUD has weighed in on this issue, and I think that is important to note, that the true innocent tenants are the thousands of people who don't use drugs, who don't sell drugs, who don't have household members and guests who do or sell drugs, but who have to live next to those who do in public housing. These are the people most affected by this decision today.
Can I ask you this?
Yes.
I take it you're not saying that the exercise, or maybe you are, that the exercise of discretion by the director of a housing authority is simply unreviewable in a state
Oh, no,
court?
Your Honor, I'm not. And in fact, the quote that I had from the Scarborough case indicates what the court's function is, to examine that in the provisions of the lease, to see if the lease was violated, and then to see what the elements of the criminal conduct were. Those would be things that the trier of fact would be reviewing.
Oh, I understand that, but I'm talking about you telling us that Rucker says that a state court cannot review the discretionary decision of a state official
I don't
as
believe
to
there,
eviction.
I don't believe that the Rucker court went so far as to
Right,
say
so state
that.
courts can still review a decision by a housing authority
It may, and as your
to
court,
evict on an abuse of discretion,
Abuse of
arbitrary,
discretion.
capricious standard.
yes, that is a reasonable standard and the correct standard to apply. What I would suggest, though, is that the court may not substitute its judgment on the discretion for that of the housing authority. Again, the housing authority is in the best position to determine what is best for that community and how that termination of the tenancy will affect those other people in that particular public housing development. We ask that Your Honors affirm the judgment of the housing court, but find that, in fact, state law is preempted. Yes.
Forgive me again. When the court in Spence against Gormley looked at 121B Section 2, it was looking to the language, the cause language of that statute. So it was, as I read the Chief Justice's opinion, it really wasn't looking at the decision of the housing court. It was interpreting the state statute, correct?
Yes, and in fact, it did define what is considered cause.
So, assuming that we agreed with you and said, absolutely, you've got to read it, you've got to consider an appeal from a housing authority's decision to terminate a tenant under an abuse of discretion standard, that still doesn't tell me which door I have to get into to take a look at Spence against Gormley, unless you are simply asking for a straight-out revisitation of the cause language of 121B Section 32. Because even if I had a case and I was using the abuse of discretion, if we've interpreted the statute to impose these requirements, it is surely going to be an abuse of discretion if a housing authority hasn't followed the law. So the door I'm going into through at your invitation and HUD's invitation is take a look at Spence against Gormley. It simply interprets the statute incorrectly.
It does. Or not so much incorrectly for 1982, Your Honor, but for now.
That doesn't help me, because when you get to statutory interpretation, we interpret it one way, and if the legislature doesn't want it, then the legislature fixes it, which it could do. I mean, I'm not being flippant about it. It seems to me...
But again, Your Honors, the cause requirement, I think, is something that the court can examine in the context of the lease changes, the federal changes, and the situation that exists now with being able to stay in a federally subsidized public housing apartment when there has been a lease violation, contrary to what Congress has wished.
Do you take the position that the violation in question is not a cause violation, but it's something separate?
No, Your Honor, it is a cause violation.
All right.
In Ms. Garcia's case, her two sons were charged with drug offenses within a week of each other, and both of those would have been violations and were violations of the lease. Thank you, Your Honors.
Thank you, Ms. Michael.